Hello everyone, welcome to my channel. So today in this video, I'll be discussing the Italian Supreme Court judgment in the case of Convergys Italy S.R.L. So this is the first time the Italian Supreme Court has accepted the use of loss-making comparable entities in a benchmarking analysis while acknowledging that the OECD Transfer Pricing Guidelines allow this under certain specific circumstances. So let us look at the facts of the case. So to give a brief background on the case, essentially Convergys Italy S.R.L. had provided call center services to a related Dutch company for which it received a 5% markup on costs. Now the tax authorities, they undertook a tax audit and argued that based on its benchmark study, the 5% markup which was determined by the taxpayer to remunerate the intragroup services wasn't appropriate for the transaction in question. Now the tax authority found that the benchmark study on which the 5% was based included certain loss-making companies. So the tax authorities removed the loss-making companies from the set of the comparables on the basis of them having incurred losses. This led to an upward revision in the comparable company margins. After removing the loss-making companies, the median markup of the benchmark study was 7.42%. It increased from earlier 5% to 7.42%. A tax assessment was issued, adding the additional income to the taxable income of Convergys. Now, Convergys Italy consequently initiated legal proceedings before the first instance court, the Provincial Tax Commission, where they received a partially favorable decision. The tax authority subsequently appealed the decision before the second level court, the Regional Tax Commission or CTR, which ruled in favor of the tax authority. Convergys then appealed this decision to the Italian Supreme Court to consider the main issue which was under this judgment was whether loss-making companies have to be excluded from the comparable set while undertaking a transfer pricing benchmarking analysis. Now coming to the judgment of the Italian Supreme Court. So the Italian Supreme Court ruled in favor of Convergys, which is the taxpayer. The Supreme Court considered that the tax authority had wrongly accepted the tax authority revised benchmark study as the amended criteria selected by the authority were not aligned with the OECD Transfer Pricing Guidelines and contradicted the principles set out in them. So the court stated that it wasn't possible to exclude potentially comparable companies solely because they have recorded low or negative margins in some years. In the normal course of business, loss-making companies do exist. So this is what the Supreme Court noted. The Supreme Court emphasized that the OECD guidelines, they don't support the outright elimination of companies with low or negative margins if such results are incurred to achieve better outcomes in future years. So this Italian Supreme Court extensively relied on the OECD transfer pricing guidelines. It highlighted the relevance of corporate strategies, market conditions, while undertaking a transfer pricing analysis. And it essentially ruled that purely if a company is a loss-making company, it should not be excluded because it is part and parcel of running a business. It can be a part of your business strategy, or it can be due to certain market conditions. However, if there is an exceptional condition because of which losses are incurred, then it will have to be looked at it accordingly. Now, this ruling is setting a radically new approach from what is being from what is being currently followed in many geographies across the world, where persistent loss-making companies are excluded from the transfer pricing benchmarking analysis. This ruling could influence not only future tax audits in Italy, but could also set a global precedent. So the court highlighted the need for a thorough examination of all relevant comparability factors, such as corporate strategies or market conditions, rather than a rigid exclusion of entities purely on the basis of them having losses or negative results. So it gives a new outlook even for taxpayers who often struggle to find appropriate comparable companies when preparing their benchmarking analysis. It offers more flexibility. It would be helpful, especially when dealing with loss-making companies. However, it also needs to be seen that how the transfer pricing world will react, or rather adopt, the principles that have been set out in this Italian Supreme Court ruling for it to have a widespread applicability across different jurisdictions. Thank you. This was all for the video today. If you have any queries, any comments, please do reach out to me by way of email, or you can drop in your comments to this video. Thank you so much for watching. See you soon.